Now back to 80/20 estate planning. Here's your host, estate planning expert, Al Gibbons.
Back with Suzanne Hecht and Kevin Danyi. Suzanne, we were talking about guardians, and I think we all found in our similar experience that everybody has a problem choosing guardians, certainly early on with kids. How do you get through the process? It would seem to me people can bog down, they go home, they think about it, and they never end up getting the will drafted, or it's much later. How do you get your clients through the process?
Well, one, we emphasize the fact that wills are freely amendable whenever people feel like it. And it's certainly better to name somebody and think about it and change it 15 times later than not to name anybody at all. And you also can't get bogged down on the fact that is, although it's an important aspect of your estate planning, it is only a part of it. And it doesn't make any sense to hold up the whole thing for one small part of it.
Mm-hmm. Kevin, same thoughts on that?
Yeah, I would think that if you get it started, it's not something that you do and just lock away in a safe. And it's really hard to get people to think about this because it's not something that you talk about at cocktail parties, right. And it's not like a new set of ping irons or a Mercedes or something like that you could say, hey, look at this great trust I have. Mm-hmm. It's something that's just put away, and a lot of people have fear of the whole process of talking to a stranger about their personal assets, and even more than that, if you dig a little bit deeper, you find some things that even they don't want to talk about, that are personal things within the family.
Right, and I guess, Suzanne, back to your point, it is only one item of the entire will and so forth that's being drawn up. In most cases, we're talking about an unlikely event. Not that it won't happen, or it couldn't happen and doesn't happen, but it's an unlikely event, and really not wise to bog down the rest of the process. But also to go further, what you had said before, selecting guardians may be one of the hardest issues that we have to deal with our clients. What about executors and trustees? What is an executor? Does that hold the process up, and should it?
I think that executor is probably the least likely appointment that holds the process up, and that is because the executor largely does not have a whole lot of discretion. So you're not really placing your faith in somebody's judgment. With the executor's job is more short-term. Their job is to collect all of your assets once you've died, to make sure that all your bills get paid, to make sure that the tax returns that have to be prepared and filed are, and then to follow the rules that you've set forth in your will in distributing the assets. There's not a lot of discretion in making decisions. And because of the short-term nature of being an executor, I think people find that job a lot easier. Often people will name their spouse as their executor and only have to come up with a backup executor in the event that their spouse predeceases them.
Okay, so Kevin, if I name an executor, and let's say it's my spouse, and my spouse either has good business sense or doesn't have good business sense, but I do understand that executors usually are spouses. So let's assume for a moment my spouse did not have good business sense. How would she get through that process? Would she work with other professionals? Would she call you? Would you help her? How does that work?
There are two ways of doing it, really. She could, or he or she, could rely upon a professional such as the attorney who is guiding her through the administration process and the CPA who's involved and whatnot. Or the other idea is to appoint co-executors. And I do a lot of this, where you pick either one child or a professional who really has the know-how to do it, or in the case of a child, is a little bit less removed from the death of their, well, not removed from the death of their father, but it doesn't have the impact that the death of a spouse has.
Emotionally and so forth.
Oh, yeah. I've seen people who just, they don't leave the house for 9 months.
Yeah.
or to a year because they're devastated by the whole thing. But I tell everybody in selection of all fiduciaries, and we'll get to this on trustees, the root word is trust. And it can't be Uncle Charlie who gets on the bus and goes down to Atlantic City every month. You do not want him to be your trustee.
Right.
Without some oversight. If you really want Uncle Charlie, get some oversight.
So I guess in that case, you say the key word is trust. I guess the key words would be trust and common sense.
Right.
In hearing about doing a good job.
As well as capability.
One thing I hear attorneys talk about when I work as a member of the team is that executors or other people involved that we're talking about now have a lot of responsibility, and they may have some liability. It's sort of a disclaimer, I think, in many cases. Is there a lot of liability that these people pick up as being executors or trustees? Suzanne?
Well, yes. The answer is yes. Yeah. There is liability in both cases. Probably more liability when you serve as trustee than when you serve as executor because of what I mentioned before, and that is the lack of discretion. Now, if you're the executor and you've been appointed and you simply fail to file any tax returns, there's going to be some liability. Right. The problem with trustees is because their major role is to see that the assets are invested prudently. That aspect of being a trustee really does raise a whole nother set of possibilities as far as liability goes.
So we're going up another level of complexity.
And length of time also.
Pardon me?
Length of time also.
Because the duration of the trust.
Sure.
Right.
And you may look like a genius as a trustee if you invested in... I have the television on mute right now. If you invested in Dell 4 or 5 years ago, boy, you were a genius if you sold it at the right time. But if you're still holding it now, all of a sudden you have beneficiaries coming to you, or worse, going to their lawyer and having the court come to you saying, "What are you doing?"
Well, this sounds pretty heavy duty to me.
Oh, absolutely.
So when you pick a trustee, let's talk about this issue of an individual trustee or a corporate trustee or co-trustees. What do you recommend to your clients? Kevin?
I have, depending on the situation, I've done both in some cases where you have a family member who really knows the personality of the people. They know that...
This is the judgment part that Suzanne was talking about.
Sure.
Yeah.
And if young Johnny turns 18 and wants a red Corvette, that's probably not a good reason to invade the principal. And if he gets into Princeton, well, that probably is a good reason. And that family member is going to have a lot better of an idea than a corporate trustee, a bank trust officer, somebody like that, who really doesn't know the people in many cases, although a lot of them go out and they visit them, but they cannot possibly know them as well as that family member.
Right.
So if you have the two of them mixed together, you get a good blend.
Do you feel the same way, Suzanne? You like corporate and individual?
I probably feel a little bit stronger than Kevin is. I think that there are certain situations that warrant a corporate trustee, but those situations are pretty far.
Suzanne, when we say a corporate trustee, let's make sure we define that. Who is a corporate trustee?
There's banks, there's institutional trust companies.
Okay.
A lot of brokerage houses now have trust powers that allow them to serve as trustees.
Okay.
And I think that there are, I've had a few cases that were extremely contentious family situations where I think a corporate trustee really played a role in sort of being the mediator. Absent that, I am not a big fan of corporate trustees.
Right. Okay. So, do either of you ever act as trustees?
I do, but only in cases only in cases where I have a pretty long-term relationship with the client.
Yeah, that's the same with me.
Okay.
I will also be a trustee for a life insurance trust, so I can make sure that the crummy letters and all those things are taken care of and 709s are filed, because
gift tax returns,
right,
and the administration of the trust.
Right.
Let's hold that thought, come back right after the break and pick it up, and let's talk about some other tools. Thank you.
80/20 Estate Planning will return after these short messages. We are a large corporate law firm and require our workflow processes to run effectively and reliably. After researching the market for a networking faxing solution that was easy to use and integrate into our group-wise email system, we chose ACPAC's FaxServe. It provides the tightest integration with GroupWise, and it allows our employees to send and receive laser-quality faxes right from their workstation. We set up the system quickly and easily, and in no time at all we were using the system. One of the greatest advantages is that there is no learning curve for the users. Because of the tight GroupWise integration, we did not need to install software on every desktop. This saved us days of installation and training time. Now FaxServe routes incoming faxes to each user's email inbox, providing full confidentiality of faxes to the designated person or persons. Our employees are now able to send faxes via their GroupWise email as easily as sending any email. Faxes are saved to the network in a digital format, so we don't have to store paper documents anymore. Faxes can be forwarded over the network, so we are not wasting paper or time refaxing the same document over and over. FaxServe is a perfect solution for your business too. For more information on ACPAC's FaxServe, visit www.faxserve.com or call 1-800-808-7000 or Viable Solutions Incorporated at 1-800-679-7626.
Money. It's just not what it used to be. Among other things, it's younger. But new money and old money have at least one thing in common. Phoenix, a company that's been helping people manage wealth for nearly 150 years. Phoenix understands that making money and knowing what to do with it are two skills. Call 1-888-456-3451 or visit us at phoenixwm.com. We can bring harmony to your life, if not to your music.
Join us every Wednesday from 7 to 8 a.m. for The Doctor is In with your host, Dr. Elliot Brown. From medical diagnosis to state-of-the-art treatments, Dr. Brown will be sure to educate and inform. From cutting-edge topics to conventional medical approaches, this interactive call-in show will help you make sound medical decisions. So join us every Friday from 7 to 8 a.m. for The Doctor is In, right here on your talk alternative, WALE 990 AM.
Talk to our expert host. In the Providence area, call 621-WALE. Outside the Providence area, call toll-free, 1-877-621-WALE.
And now back to 80/20 Estate Planning. Here's your host, estate planning expert, Al Gibbons.
Welcome to our listeners. Welcome back for the fourth segment. Suzanne Hecht and Kevin Danyi, welcome back. We've been talking about trustees. We've been talking about corporate trustees and individual trustees. Let's talk about trust for a minute. We don't want to go into great depth about it, but let's make some comments on trust. Suzanne?
I just think that it's important for folks to know that there's really three main reasons to have trust. One is to get some tax savings. Trusts are sort of the cornerstone of taking advantage of your unified credit so that you can do some federal estate tax planning. The second is when you have minor kids, trusts are very important. I shouldn't even say minor children. When you have heirs that you're not comfortable with how they would manage and administer the money, if you were to give it outright to them, trusts can become very important. Sometimes those trusts last only a little while until the child turns 30, or sometimes they last lifetimes if you don't think that's ever going to resolve itself.
Okay, good. Kevin, any comments on trust?
The way I explain trust is it's kind of an intimidating thing. People think of Rockefellers and Kennedys, and I call it Danyi's theory of trust. A trust is nothing more than a briefcase or a suitcase. It is a thing, a bag, that you put something in. And the terms of the trust determine how you get the things out. And there are all different types of trusts that are out there. There are dozens and dozens, and they all serve different purposes. What bothers me is some of the people that go out there, and I consider them to be outright hucksters, and they prey upon elderly people, lower income people, and they say, put all your money in this trust and avoid probate, and you won't have to pay any taxes. And that is simply untrue.
Now, what kind of trusts are you referring to in that particular point?
Well, an example was one I had a few months ago.
I mean, is that the living trust that people talk about?
Right.
I think that's what we're talking about, funding a living trust, a revocable trust while you're alive.
Okay, a revocable living trust. Now, that was a pretty strong statement you made, Kevin, and I think most of us in this specialty understand that there's no great tax savings. Are you saying that living trusts are bad in general, or just that they don't deliver on tax savings?
They don't deliver on tax savings in many circumstances like this. What I
so
gave
it's not
you
the kind of trust that Suzanne was talking about that really can impact tax savings.
Right.
That's a different kind. So you're being very specific now about revocable living trusts.
Yes.
Okay.
And the example I gave, these people, they lived in a $40,000 row house and had, maybe $10,000 in the bank and a defined benefit pension. They had trust documents that were 2 inches thick, and I am not exaggerating. It was unbelievable. And it cost them somewhere north of $4,000 to have this done by a non-lawyer, and none of it served really any purpose at all. There were 1 or 2 things in there that were good, but most of it could have been accomplished with a power of attorney. Or
it would seem to me, the way you just described it, with what Suzanne was talking about earlier, entitling. For example, if you had a home, it could be joint, so it avoids probate. If you have a defined benefit pension program, that doesn't go through probate.
Right. It ends.
So most of their assets don't accomplish anything by being in the living trust. But isn't it also true, because this is a national audience that we have, that the probate costs, which we won't talk a lot about today, but the probate costs in Pennsylvania are not particularly high. It's a relatively easy process to go through compared to some other states.
Absolutely. Pennsylvania is simple.
So if Pennsylvania is simple, there may be states where people of assets, people who for privacy or for probate avoidance or for management of properties that they own in different states, might consider a living trust, but not for tax savings.
That's correct.
Did I say that?
I think you hit the nail on the head.
Okay, because that is one of the most misunderstood. We've all had clients come to us and say, I want one of these because it saves taxes. And in fact, they are, in many cases, overused, they are overpromised, and they underdeliver.
If they truly avoided taxes, there would be a line down Broad Street by my office so long that it would be like the deli.
Well, I'm glad we talked about that. I think that that's an important issue, and I'm glad we brought that up. I do want to talk and end our show with a discussion of a few other tools that are available to us in this process. We've talked about living trust now. We want to talk about durable power of attorney. Boy, that sounds imposing, Suzanne.
I think that's one of the most important parts of a well planned estate. And I think the easiest way to explain is a will is.
Suzanne, before you explain it, let's do this. Let's take a break right now. This is too important to break up. Let's take the break, and then we'll come right back and talk about durable power of attorneys, okay?
Okay.
Thank you.
80/20 Estate Planning will return after these short messages. We are a large corporate law firm and require our workflow processes to run effectively and reliably. After researching the market for a networking faxing solution that was easy to use and integrate into our group-wide email system, we chose ACPAC's FaxServe. It provides the tightest integration with GroupWise, and it allows our employees to send and receive laser-quality faxes right from their workstation. We set up the system quickly and easily, and in no time at all we were using the system. One of the greatest advantages is that there is no learning curve for the users. Because of the tight GroupWise integration, we did not need to install software on every desktop. This saved us days of installation and training time. Now FaxServe routes incoming faxes to each user's email inbox, providing full confidentiality of faxes to the designated person or persons. Our employees are now able to send faxes via their GroupWise email as easily as sending any email. Faxes are saved to the network in a digital format, so we don't have to store paper documents anymore. Faxes can be forwarded over the network, so we are not wasting paper or time refaxing the same document over and over. FaxServe is a perfect solution for your business too. For more information on ACPAC's FaxServe, visit www.faxserve.com or call 1-800-808-7000 or Viable Solutions Incorporated at 1-800-679-7626.
Today's money. It's not just who you are, it's what you're made of. It's not just having a name, it's making one. Not just being, but creating. In fact, 8 out of 10 today's millionaires aren't inheriting their money, they're earning it. That's not just evolution, that's revolution. And one company understands how money has changed, and that company is Phoenix. Call 1-888-456-3451 or visit us at phoenixwm.com, because money is not what it used to be.
Oh no, this is a brand new car!
Don't worry, let's not call the police. I'll give you my name and number. If you have any problems, call me. My friend owns a body shop.
This is a toll-free call. 1-866-LAW-RADIO.
I'm sorry, ma'am. It appears that the surgery did not go exactly as we expected.
This is a toll-free call. 1-866-LAW-RADIO.
Experienced and professional legal representation is now a phone call away.
This is a toll-free call. 1-866-LAW-RADIO.
Whether you've been wrongfully injured, you're buying a home, or are involved in a legal dispute, you need to know your rights, how the law applies to you, and how to avoid or solve a legal problem. Now you have the information you need. This is a toll-free call, and you will receive a free consultation.
This is a toll-free call. 1-866-LAW-RADIO. 1-866-LAW-RADIO.
When you need to speak to a lawyer, call anytime after the show or at your convenience, or just anytime you need to speak to a lawyer. Call toll-free 1-866-LAW-RADIO.
You're listening to Southern New England's Talk Alternative, offering the most unique programming. 990 WALE Renaissance Radio.
And now back to 80/20 estate planning. Here's your host, estate planning expert, Al Gibbons.
Suzanne, we were talking about durable power of attorney. What is that?
A durable power of attorney is a document where you designate another person that can act on your behalf, mostly in financial and business and banking and matters of that sort. If you have a general durable power of attorney in place, you'll never have to go to court to have a guardian appointed. I think that the analogy that, you do a will is to life insurance as a general durable power of attorney is to disability insurance. It's the document that applies before you die.
Yeah, that's a good analogy. I like that.
Yeah, I do too. Suzanne, one thing that I've seen on durable power of attorney is that I haven't seen drafted very often a springing durable power of attorney that only comes into effect when you're disabled. This general durable power of attorney, typically, could be used even if I were in good health, could it not?
That is correct. It's a very powerful document, and you certainly have to be diligent in what you do with the document. It's our practice to hold the originals of powers of attorney.
You as attorney
yes.
hold and why do you do that?
Well, because they are effective, and someone could use them immediately. This way, someone calls and says, I need Joe's power of attorney, we're certainly going to ask at least a minimal amount of questions, like where's Joe, and what is wrong with Joe.
Okay, so that's how you protect your client, because there really aren't effective springing durable power of attorneys that just come into effect.
I think they're completely ineffective,
right,
because by the time you can prove that someone is incompetent to prove that the power of attorney is effective, you're basically back in court.
Fine. Okay, I like that. Kevin, what is a living will? What is an advanced medical directive?
What we did under Pennsylvania law in 1991, there is a statute that says, people call it the pull the plug legislation, saying that you have the right to die with dignity. What we've done in our office is we've combined what we call a health care or medical power of attorney with the living will. And it says that if I...
Are they two separate documents?
I put them together. It saves money for the client.
Okay.
And it's one less document to be lost, or actually we keep things in a bank vault off-site.
Okay.
But what this says is if I pull out of my driveway, get on the highway, I'm in an accident, and I'm in a coma, I cannot communicate with my doctor, then my wife has the power to make decisions for me. I also have in there specific...
What decisions?
Any possible medical, surgical, dental, whatever is out there. She can do anything.
Yeah.
And it also has what my wishes are. Now, suppose my wife is in the car, she's killed, I'm still there, I'm in the coma, then the kids come along, or whoever else it may be. It does two things. It gives them the legal authority to do that. It takes the doctors and the hospital off the liability hook, and that is a big concern, and it keeps them out of court. I keep coming back to that. Stay out of court.
Well, it sounds like a very important document. The durable power of attorney, very important. The will, the sort of the foundation of the whole thing. Guardians, executors, trustees shouldn't hold up the process. We have covered a lot of territory today. I want to thank you, Kevin, for being with me, and Suzanne, thanks so much for being on the program.
Thank you. We've enjoyed it.
I think it's been a very beneficial program. I want to thank Phoenix Home Life, our sponsor, a truly outstanding insurance company, one that I've been proud to represent over the years in giving cases in the estate planning arena. And thanks to them, and thanks to all of our listeners, and we'll look forward to seeing you here again next week, Tuesday, 4 to 5 p.m. Thank you.
Thank you for listening to 80/20 Estate Planning with your host, Al Gibbons. You can tune in to our live broadcast every Tuesday at 4 p.m. If you would like to contact Al Gibbons, you may email him at algibbons@algibbons.com or mail your questions and comments to AEG Financial Services, The Commons at Valley Forge, 1288 Valley Forge Road, number 53, Phoenixville, Pennsylvania, 19460-2681. Please join us again next week.